Good morning, Maksym. Welcome at stage 2 of the selection for HQCJ, stage of the interview. Your interview will be conducted by the selection commission in its full composition, made of Tadzazhechny, me, Sergei Varlanov, Robert Bergheisen, Stephen Markman, and Yevhen Mezintsev. The rapporteurs for your interview are me and my colleague Tadzazhechny. Should for any reason our interview be interrupted, we will definitely resume it on a different day and at a different time, which we will agree with you. The commissioners will be asking you questions. We are asking you to answer them in a precise way. A commissioner asking you a question has the right to limit the time for your answer. I think that you've watched a number of interviews, at least I'm assuming that, and you know that at the very beginning we are giving our candidates a platform for their self-introduction remarks, and you will be given the same opportunity. So we are passing the floor to you, Maksym. So what is it about your motivation that you'd like to tell us? You're welcome. Good morning. Let me first introduce myself. I'm an entrepreneur first, then a lawyer, an academic, a father. I'm a cyclist. I enjoy traveling somewhere by bike. I'm using the bike all the year round. I'm a product manager in the best legal tech company of Ukraine, just not. So we are developing CRM systems for lawyers and attorneys at law, system for making prognosis in legal decisions. So the things that I wanted to tell you are as follows. So the court is a place where services are being provided, and these services must be quick and efficient. If we are talking about this triangle, people, resources, and time, when dealing with people, we have to say that a court is not a research institute. There is no absolute truth. There is no absolute justice. And we must understand that nobody wants justice that lasts for a very long time. If we have a dispute, it must be settled within reasonable terms in the most efficient way, in terms of different resources, including financial and time resources. So thank you. That was a very short introduction. Maksym, when are the judges going to start using the GPT chat to start writing their court decisions? Well, let me tell you that GPT chat is just a helping tool, but it's not always good. We have many simple cases that can be solved without ChatGPT, without referring to the decisions of the European Court for Human Rights. What we are lacking is correct or categorical, let me say, identification of facts. So the main problem of our court decisions, which are impossible to read, is that we are quoting different norms of the law, and then there's this phrase, the party has not proven their position, but it's not clear what the reasoning for that is. Yes, of course, we can use ChatGPT, but we are again saying that any kind of service, e-service, the use of AI, even if we are referring to those services, it must be the human who reviews the result of such a service made by e-service. So we can use either algorithms in this case, or discussions, or maybe templates, I don't know. But we should do it in an efficient way, that's what I can tell you. Okay, thank you. So, I will now quote your motivational letter. So I believe that the majority of our judges are professionals and competent people, and these professional, competent judges are arrogantly using their mandate against the law. So these professional, competent and diligent judges are making decisions that follow the law, but in essence are abuse. I'm not going to remember a quotation by one of the judges of the Supreme Court of the United States, but in essence what he said was that when he was addressing students, he said that you are going to realize that you are a judge when you start making decisions that you dislike. And in the context in which he said that, he meant that the decision that one may dislike is lawful. So could you please explain this quotation of yours? Are you urging the judges to violate the law and to pass decisions that everybody will like, but that will go against the law? No, no, no. A decision cannot be liked by everyone because one party will always be upset, and the court must definitely follow the law, but the question is that we have to interpret the law and we have to identify the circumstances under which we are applying specific norms of the law. And here we can see how professional and competent judges are, because when we are reading their judgments, we cannot understand what they meant. Then we have this judgment, which does not correspond to motivation provided in the same document. So it's a kind of a scheme used by judges. So you see that a party is using a specific scheme. So let's look at bankruptcy. When somebody is selling their assets, then the right of ownership is transferred and everything appears legal. Yes, and even the court says that it's legal, but the law was used for the creditors not to get what they were owed. Yes, yes, I understand your example, but in your opinion, Maksym, what is the reason for judges interpreting law in this distorted way? Why is this happening? So let me explain. I'm not saying these are all judges who are doing this. These are some specific cases, of course, but we have a certain amount of judges who do this, and we cannot ignore this amount of judges because it's already too much. So sometimes people will do that to avoid some problems. In my motivational letter, I mentioned the judicial dossier, and I don't like this indicator, the number of cancelled decisions. A judge is a human being. So we are all talking about impartiality, but still they are a person. And if we are looking at this indicator, the number of cancelled decisions, then it means that we need to look at those judgments that were appealed. So we had this case in my practice when the appellate court did not cancel the decision, but the Court of Cassation canceled the decision of the appellate court. And there was a retrial, and everybody was pointing to mistakes in the decision. So it appears that nobody wants to have their decisions cancelled. That is why the decisions are made in such a way that everybody is satisfied. So I understand you, but how do we solve this problem? I know there is one solution. We have Kannonen's theory. So the essence of the theory is as follows. So a person sent one and the same task to two departments of two consulting firms, and the person received two completely different offers in terms of price, quality, and content. So definitely all this affects a judge. Maybe a person who has not yet completed qualification assessment, they are thinking that they don't need to have any canceled decisions. Maybe they're thinking, why do I need to listen to the Court of Cassation? Yes, here we can talk about corruption, but it's not corruption per se. Everybody is speaking about corruption, but a judge is a human being, and we must be talking about creating some mechanisms under which this subjective attitude is decreased, when we don't have that many indicators, when we don't have that many reasons. So that instead of 6-7 pages, we are having 30 pages, and it's impossible to read all these documents. So let's use some referring points, just saying that I've identified this and that fact, and I've applied this or that norm of the law, and that's it. We are talking about the application of formal logics when we are referring to some norms, and then we are making the final decision. And I believe that if judges have a mechanism work out, a simplified mechanism work out, and a judge will say that they are not applying specific norms because they believe 1, 2, 3, and 4, I think it will enhance the quality. So, Maksym, please help me understand. But you're talking about an algorithm or a mechanism that we already have in our procedural codes that the judges are following. Or are you suggesting an alternative here? I don't quite understand. Yes, we cannot violate the procedure, of course. And I hope that there will be a question about service, about the proceedings, but in this specific case, we are talking about the application of law. And we are saying that judges can take some simple categories of cases when we have very typical evidence, typical structure, typical circumstances, and we can create a checklist based on all of the above, and a judge will go through that checklist. So it's not a replacement to the procedure, but it's just support or help. And this will help us decrease any potential influences on the decisions made by judge. Thank you. With that, I'm passing the floor to my colleague, Ted Zarzeczny.
Yes, good morning, Mr. Selivanov. I think we all agree, Mr. Selivanov, that technology offers a great deal and offers much to support the work of many activities, commercial and institutional. And there is no question that the High Qualification Commission of Judges can also, of course, improve its operations by some of the technological innovations that are available and appear to be provided by your law firm to assist. However, I do, in reading the material that you have provided to us and that we have received in addition with our own inquiries, that your contribution to the work of the HQCJ is in the field of technology. And you have many suggestions that you make in your motivation letter about how you can contribute to the work of the HQCJ if you're chosen a member. With that context, we have a saying in North America that there are ways to get the milk without buying the cow. And it strikes me that the kind of expertise that you have can be useful and can be acquired through a consultancy engagement. You are not here, however, to provide us with your proposal to act as a consultant. You're here applying to be a member of the Commission. And the Commission is very concerned with the qualitative evaluation of candidates for judicial appointment and perhaps judicial advancement. I don't see in your biography any claim that you have of personal experience in the courts and personal experience with judges. If you have such personal experience, I welcome to have you let us know a little bit more about that.
If I may, I would like to clarify your question. Are you interested in the procedural method or me working with the civil society? So what are you interested in? Me involved in the proceedings or working with civil society outside?
Yes. Do you go to court, and have you had cases in the courts? And if so, what is your experience?
Yes, thank you. Now that's clear. So I'm a practicing lawyer. I represent clients in courts. I've been doing that since 2001. I've been representative in different kinds of cases. I don't deal with criminal cases. The focus of my interest, and I used to work at Arbitis law firm, and it still exists. It's quite successful. So we worked with intellectual property rights. We worked with companies, and those were also disputes with the tax administration. So when we are talking about my experience with the courts, I have this experience because I was representing clients in courts. I have quite a vast experience, but the only exception is that I don't deal with criminal cases.
Now, just to follow up on that, if you have dealt with cases in court, you would have, of course, had then professional acquaintance with the judges that preside in those cases. What are your concerns with respect to the functioning of the judiciary and the approach that judges currently take to their work?
Again, I may be repeating some of the ideas, but I'm concerned about the fact that judges do not see a court as an institution that provides services. So let's look at your commission. You start your interviews in time. It's announced that we start at 10 a.m. and we start at 10 a.m. It's a great plus, and it gives us trust in your procedure. If we talk about the judiciary, you can show up at the court at 10 a.m., 11 a.m., or 12 a.m., 12 p.m., but the hearing may start at 2 p.m., 4 p.m., and I even had a case when in administrative appellate court we had case hearing set for 9:30 a.m., but it started at 7 p.m. So this is bad planning, first of all, and I would like for the court to have this positive and respectful attitude towards parties to cases. We have some positive progress already. When the judge has fallen sick, the assistants are not waiting for the parties to show up to court, but they give the parties a call telling them that the judge has fallen sick or that the judge is away. But unfortunately, these cases are not frequent. I would like for this to become a system.
Yes, well, again, your focus seems to be on procedural issues, but you do say in your motivation letter that competent, conscientious judges who render judgments that correspond to the rule of law, but in fact are humiliating and offensive. Now, that's strong language. In your experience as a lawyer, have you personally experienced these kinds of approaches or attitudes from a judge?
I would not have written about that if I didn't have that kind of experience.
All right, so your answer is yes? And then you
Yes.
also make the point that judges openly and defiantly use the discretionary powers granted to them illegally. That is a very serious accusation. And I'm just wondering again what you mean by that.
So I was talking about their position and mandate. So I like being specific, and let me provide you with one example. An example from my own practice. We were representing the interests of a tourist company, a travel company. And there were some even criminal proceedings initiated against that company. And when we were talking to tourists who were dissatisfied with the services of that company, so we were told the story that a judge showed up and said that they appeared in front of that travel agent and demanded reimbursement of her money simply because she was a judge. She showed at that travel company demanding reimbursement, and she was very entitled in her attitude just because she was a judge. Yeah, so this is an example I can provide you with. And there are other examples when we can see violations of traffic regulations. So instead of paying a fine, judges start abusing their position. And this is a problem with their integrity.
I see. The reason I ask these questions, of course, is to try to understand better your motivation for becoming a member of the High Qualification Commission for Judges. You've expressed these rather serious concerns about your experience or that of your clients with judges. What would you propose, quite apart from the technological influence and emphasis that you put on your approach here, what would you propose to assess a candidate in order to be satisfied that these examples that you give would not be present in candidates seeking the High Qualification Commission appointment as a judge?
So here I would say that I cannot suggest anything drastically new, because we need to study as much information as possible about a person, analyze their lifestyle, study some minor but maybe critical behaviors in different situations. So we can break it down into three components. So minor, medium, and critical things, and assess the behavior of a person in those three types of situations, which will allow us to make some conclusions, preliminary conclusions about a person. We cannot be talking about red flags, of course, because nobody is perfect, but we need to tick as many boxes as possible before we can categorically say that a person can be appointed as a judge or otherwise. For me, this indicator is important. How a court president is elected. So the law tells us that a court president should be elected once. But what do we see? So we see that when a president, when their mandate expires, they are resigning before the expiration date, and then they reapply for the same position. So what does it tell us? It tells us that they are using probably a legal way, but in essence, this does not correspond to the law, because one and the same person cannot be the president of the court twice. It's just one situation, just one indicator, and together with civil society, we can work out on a number of such indicators. I don't know everything, but of course we can involve professional assistance. We can work with the civil society in order to get these indicators, in order to have these facts that will help us select the best candidate for the position of a judge.
Thank you for your answer. I'm going to turn the matter over now to my colleague, Mr. Mizantsev.
Thank you, Dad. Доброго дня, пане Максиме.
Good morning, Maksym. Let us continue our communication. For our audience, let me provide some information about your financial standing. So you have 2 apartments in Kharkiv, 69 and 82 square meters. You have a car manufactured in 2013, which you bought in 2016 for more than 500,000 hryvnia. So we have checked this price, and it corresponds to the average market price. So there are no questions here. The question is as follows. The income of your family in 2021 was quite high. I will not be mentioning the specific income. It's high, even if compared to the salary of a Supreme Court judge, and your savings, which you declared in the same year, are almost the same as the income of your family for the same period. Of course, you could have saved the money, but at the same time, why do you keep this much money in cash? Well, first of all, I could not ignore the information about the looming war, and for that very reason, I was keeping money in cash for a rainy day, yes? So I thought that if anything was to happen to me, I wanted for my family to have this money. That's clear, thank you. So you also participated in the selection for the Cassation Court within the Supreme Court of Ukraine in 2018, but you stopped your participation, you withdrew your candidacy. So could you please tell us what caused this change of attitudes towards a judicial career? So I wrote about that in my motivational letter, and I can repeat my argument. So I completed my participation in the selection, and then I did SWOT analysis of the candidates selected. So I chose a person who was more close to me, let's say, and I was trying to compare the activities I was trying to analyze the activities of the Commission, and it appeared to me that the Commission was not really fair in the assessment. So I arrived at the conclusion that I could not legalize a competition in which I believed that people were not fair. So I didn't want to give them a chance.
За даними, які ми отримали з зовнішніх джерел,
According to the data that we've received from external sources, a local Kharkiv court issued a court writ on collection of a debt.
зважаючи на ваші доходи,
So, in view of your income, in view of your quite good financial standing, what is the reason for you having this debt on utility bills?
на сумнів до доброчесності,
So it's not something that leads us to questioning your integrity, but maybe it tells us that you're not very disciplined in terms of your finances. So what was the situation with that debt and how did you pay it off? So I did not pay it off. The writ expired. I don't remember. No. There was the expiration of the statute of limitations. So, and let me explain the circumstances. So the apartment where we lived for a year and a half, it had a really bad heating system, and it was very difficult for me to call the utility company every time, so I just stopped paying them.
питання щодо майна, знов-таки,
So, thank you, that's clear. Another question with regards to your assets, that is going to be my final question about your assets. So, between 2016 and 2019, your wife had a power of attorney for a car, Hyundai Sonata, and the power of attorney was issued by Mr. Holovash. And in the declaration for the year 2017, the right to use that car was not reflected. So the power of attorney was not issued to my wife, but to me, first of all. So it's the car of my partner, and actually it belongs to his father. And he asked me to sell it, and that's what I did. So I used that car for 2 weeks. It's all simple. So the power of attorney lasted for another 2 years. No, it was issued for 3 months. The information that you're having is not correct, because the power of attorney was issued for 3 months, for 3 years, but it appears that you were using it for a much shorter period of time. Okay, thank you. So, should you be appointed as a member of HQCJ? What is your opinion? Because we are currently having martial law and because we are having current situation in the country, do you think a judge should have additional guarantees of their independence? And if yes, what are those guarantees? Personal protection, maybe weapons, maybe something else? Oh, I can tell you that there's no absolute independence, and any additional guarantees, we are again talking about effectiveness and the taxpayers' money. If there are grounds for these additional measures, maybe we need it, but in general, it's dangerous everywhere, but we have people living in different places, and we cannot talk about specific guarantees of personal security for judges. I don't think it's expedient. So you say that it would be feasible if there are any specific threats to the life of a judge or a member of HQCJ. No, I'm not talking about specific grounds, because we will have to prove that, but we are talking about some kind of reasonable doubt or suspicion in this case. Thank you. So you, as a specialist in automation processes using of legal databases, must have thought about things that could be automated in the operations of HQCJ, in the internal operations, document keeping, or maybe the things that are used during selection or assessment of candidates. So what would you like to introduce?
Well, in fact, there could be a lot of things. We have to create an open database of the work of judges, of the list of staff members. Nobody knows how many judges we need according to the list of staff members of all courts. So we should make an audit of the situation, and should be an open audit because it will allow civil society to help the members of the HQCJ. Drawing attention to unfilled vacancies and analyzing any possible disputes, because we're talking about services. And they could actually help us analyze the need for the availability and operation of a certain court. Also, the HQCJ should have the document-keeping system that would enable us to have a so-called picture or photograph of a workday of every staff member in order to make conclusions where his work can be improved, what he is generally doing. You know, there is a movie, A Person Who Has Changed Everything. It's the title of the movie. Maybe it's a little bit different. I hope that you have watched this movie. That was a baseball team. I hope you have watched the movie. No, I haven't. So there was a team, a baseball team, which lost a lot of people, a lot of games, I'm sorry, because they had just all the starring players. But they took a mathematical approach and decided not to pay that much money to the stars, but just to have, instead of one star player, 3 team players who had worse indicators, worse results, but in general, altogether, they scored better. And they started winning as a team. So I think that this approach could be introduced into the operation of the HQCJ. We have to clarify what tasks we are solving and what we need for that. Like, you know, the armed forces are not talking about unit technologies, so the same refers to courts. There should be units that settle special problems. Clear, thank you. And let me give the floor to my colleague, Stephen. You're welcome.
Thank you, Mr. Selivanov, for your participation in the competition here. My colleague, Mr. Zarzechny, asked you a question about your statement having to do with humiliating and offensive things, and you responded. And my other colleague, Judge Mashenko, asked you a question about that same sentence, and you responded. And in your response to him, you said, we are reading the court's judgments and we cannot understand what they meant. I'm listening to your criticisms of their judgments and I can't understand what you mean. So let me focus on the same sentence. I think it's an intriguing sentence and it deserves more inspection and dissection. It is these professional, competent, conscientious judges who render judgments that correspond to the rule of law but in fact are humiliating and offensive. Will you try a third time, please, and bear with me? What does that mean exactly? What are you saying about the judges who are the subject of this competition? We are trying to enhance the judiciary of Ukraine by this competition, and you are raising a critique, apparently, of judges, and I do not understand your critique at all.
Well, let me give you an example. Maybe it's going to be easier to explain this through an example. Let's say there is a bankruptcy case, a large bankruptcy case involving 5 or 7 people, and they are all called to court, and there are 2 issues: acknowledgement of the auction as invalid and requiring the property from somebody's illegal ownership. So the first part is settled. It goes through all the 3 instances, there is a positive decision, and then comes the second part. Well, in fact, the decision is there because the property is no longer owned. It stopped being owned by somebody on illegal grounds. But judges of the appellate court claim that this property should be given back, but then the cassation sees that this one of these people is involved in the case, and then this person says that he or she was not involved. I was involved in settling the issue about the auction, but I was not involved in the second part of this case. And then the decision is cancelled, it goes to trial court again, and it starts all over again. Well, seemingly, that everything is legal because we have some procedural laws saying that the person not involved in the case, if a person was not involved, the cassation court should cancel the decision and give the case back to the trial court. But the cassation court does not check whether the person was involved there or not. It does not study the procedural documents which say that the person was really a trial participant. So, in fact, this is performance of the law, but it's kind of dubious or wrong. And this was done by high-level professionals.
Well, doesn't the rule of law presuppose that the individuals who are being made subject to the law were properly situated to be made subject to the law?
That's what I'm explaining. In one case, bankruptcy case, there were two separate units of problems. And this is a little bit formal because it says that this person was not involved in the settlement of the second part of the case. So all the summons were there. So it's formal mistake.
Let me ask you a couple other quick questions, sir, if I can. You say, to my mind, it is unfair to participate in a competition I have no trust in. Can we clearly assume that because you are participating in this competition, you do have trust? You indicated we start our hearings on time. We're proud of that. But you do have trust in this competition. Is there anything beyond the fact that we're punctual that causes you to have that trust?
Well, let me split my answer into two parts. I trust this commission, and I trust your words. You have said that there is no objective criteria. You said that your conclusions are subjective. You told about this honestly, and I agreed to that. That's why I'm in this competition.
You're in the competition because we are making subjective decisions? Is that what you're saying?
I just believe that your subjective judgment will be better than the previous selection had. And I have expectations and hopes like this. I'm not sure that I don't have legal grounds to believe in that, but I think that you also are striving for changes for the better in the Ukrainian judiciary, because we cannot kind of freeze what we have now in the judiciary.
Let me clarify one more point with you, please, sir. You referred to the psychologist who made an opinion regarding the level of your integrity as low and the level of your ethics as average. Are you saying that we should have a psychologist involved in this process, or we shouldn't have a psychologist involved in this process? Reasonable arguments can probably be made in favor of both positions, I think, but what is your position? Is psychological testing something that you would encourage if you were placed on the High Qualifications Commission, or is it not something? If you give credence to psychological testing, this is not an entirely good summarization of the candidate, is it?
Well, I actually give credibility to testing because I think that it's a good thing. Well, But the opinions made by the psychologists were really not conforming with reality because to what he it did not conform to what he wrote in the reasoning part. That's why when we speak about psychological testing as such, I do support it as a tool. But the only thing is that in this specific case, any opinion or any conclusion of an expert should still be critically assessed. I mean, it should not be taken as a 100% basis. Let's say that, come on, this expert has told this and we could not be acting any other way. You can always critically assess even an expert opinion. You can have a look at it, see the reasoning behind it, and that will give you a more objective and a more comprehensive picture of the candidate.
Well, that was going to be my last question, but I have to respond to what you just said here because I thought a few moments ago you said that you admire the work of this commission because of its subjective work. And now you're talking about psychological testing, which, whatever its merits, is certainly fairly classified as objective analysis, isn't it?
Well, I think that we could treat psychological testing as an objective tool. The testing conducted by psychologists was objective, and some things that I have mentioned really conform to reality. But as far as opinions and conclusions are concerned, I disagree. The conclusions should be made not by psychologists, but by a commissioner who is passing a decision. That's what I mean.
Okay. Well, thank you very much, sir. Let me turn the questioning over to my colleague, Mr. Broekhuizen.
Yes, Mr. Selivanov. When I read your motivation letter, I needed to think a bit about it. One of the things that struck me is that you say that you quote in your letter a opinion of a psychologist about you. And it says that the candidate is motivated, sociable, strong system of values, etc. Do you agree that this is a correct quote in your motivation letter? Or is it not a correct quote in your motivation letter?
Yes, the quote is right. It's correct.
So this psychologist, when he wrote down this message about you, was right.
Let me tell you even more. I agree not only with this citation, but about the weak points the psychologist mentioned, and I also quoted them in my motivation letter.
Okay. Yeah, you quoted in your motivation letter, but he also says, so sometimes he does not adhere strictly to disciplinary framework and boundaries in his work, which explains the low indicators of discipline and the probable tendency to counterproductive actions. Do you believe that we need to select someone who does not adhere to disciplinary frameworks or boundaries in his work and has low indicators of discipline and has a tendency to counterproductive actions?
Well, let me explain it. The psychologist also wrote that the testing was primarily meant for the civil servants who are under subordination. I am a businessman. I'm an entrepreneur. I create a task and I solve the task. I do it on my own, and I'm not limited to any disciplinary framework as to how exactly that should be done. And that's what I honestly told during the psychological testing session. I'm not a subordinated person. I have my own vision. I'm a businessman, and I'm trying to bring this vision into life. into reality. And if there are some limits that will not allow me to do this, I will not go beyond these limits. But I will keep producing new ideas, even if they are absurd. I want them to be discussed. And I want the decision to be passed on the basis of that discussion, and we will follow that decision.
So if I summarize your answer, the answer to my question, was the psychologist correct in saying this, is yes.
Well, let me tell once again that everything that was written by the psychologist in the reasoning part really conforms to reality. But the conclusions, the generalized conclusions, are probably more for civil servants and for the people who for quite a long period of time been somebody's subordinates. I don't have these qualities. I don't have this situation, and that's why I always act within the generally established procedural norms, as psychologist has also written, by the way. But I have creative decisions, creative solutions.
But the question I had to you, you're a guy of data. It was a yes or no question. You have a quote of a psychologist in your letter. You refer in your motivation letter to that quote of this psychologist. I asked you 4 times, is it correct or not, this quote? And listening to you, you give a very long answer, but my idea is that you mean to say yes. Is that correct?
Yes, it is correct.
Thank you. But then the next question is, of course, a logical one, and that is, do you believe that this commission should be selecting someone who has a probable tendency to counterproductive actions? What do we need in a selection commission of judiciary? Someone who will not abide by the rules but invents his own rules? Should we have someone like that? How creative you are?
I think that the Commission has actually taken the right approach for selecting candidates. You have just said that you would try to choose the best of the best. If I am the worst, I will understand that you have chosen the best, better than me. That's it. I'm not a barrier. Well, I don't consider myself to be better than others. I will trust in your opinion. And let me stress once again that I have no doubts concerning the work of your commission. I believe that your subjective commission decision is really going to be for the better of the judiciary in Ukraine.
The point is that when I read on in your motivation letter, you say that the same psychologist regarded your level of integrity as low. And then you say, let's say, not a very clear line, that apparently the psychologist was wrong here. And apparently he was right in the former, let's say, paragraph in his report. And if I read what the psychologist apparently wrote here, it's a short conclusion of the paragraph you just, after some difficulty, said was correct. So I can follow the conclusion of the psychologist. So if you are someone who doesn't adhere to boundaries and go your own way when you feel it is necessary, then I can understand that for certain jobs you are considered, especially jobs in the judiciary, you consider someone with not sufficient integrity. What do you think of this?
Let me draw your attention to the stresses we should have. In the reasoning part, the psychologist wrote about the possible predisposition of the candidate to counterproductive actions. Possible one. He did not make a conclusion in this respect, and he mentioned that this is related to the fact that the person is a businessman, and that's true. But the conclusion concerning low or medium level of integrity or high level of integrity was the conclusion not for the psychologists to make. I think that the experts, the commissions had to reach a certain conclusion. And I hope that the commission will probably assess this opinion and decide whether the psychologist has been right or not. In fact, I will not know what your reasoning behind the decision on me in this competition is going to be.
Neither do we know yet, of course. That was my last question, Judge Selivanov. It's your moment of glory.
Thank you, Robert. Maxim, good morning. So here are my questions to you. In your motivation letter, in paragraph 1, you indicated that you don't think that you are the best of the best. And several minutes ago, while answering Robert's questions, you also stated a thing like that. And this shows that you have quite an adequate self-assessment. But you claim that you are sure that you can be a member of the team that will manage to develop the composition of the judiciary that will include people of integrity. So why being so confident about this, that you can really develop a good composition of the judiciary, people of integrity? Well, again, to avoid any further questions, I can confirm that I do not consider myself to be the best of the best. I'm not a perfect man. I'm just a person who performs his work in a diligent way, in a high-quality way, but is a little bit dissatisfied with the results, as usual. And we are a team. I am a member of one team that is now working with me, and the work is related to certain standardization, the identification of certain criteria. We are working with some automation means in the legal business, and this product, as for me, is one of the best in the legal field now. So these are my characteristics, and I think that I can use these characteristics of mine while working in a team and working at the selection of judges. I know what the theory of noises is about, and you understand that. I understand that. In the morning, you can pass this one type of decisions because of your mood, and at the end of the day, your mood can change and you can be passing different decisions. This is something that is objective, and to reduce this effect of noises on the judge or on the commission, well, the only thing to do this is to set a certain number of criteria, set a certain number of indicators. So you need to establish the indicators, then you need to get the data on those indicators, and then the discretionary powers of assessing this or that indicator will be going down from time to time. You can revise or reconsider the indicator and say that, okay, in spite of the things that the machine has shown, has generated, I don't think it is true. So it can be something to revise. Okay, thank you, Maxim. And here is the next question. In the course of the interview, you suggested some changes that you consider to be necessary for the new HQCJ. And among such changes, you suggested making the indicators of judicial activity open, public, and also having the open register of judicial positions. So what about those changes? How are they going to improve the role of judges? Well, first of all, this will enable judicial candidates to know about the positions, the vacancies available, and this will also enable the public, the civil society, to analyze the candidates coming. They will not have to look from scratch for all the all the data about courts. Well, I've also written that there must be some registries open, or some indicators should be open, but there should be also some closed indicators. I mean that the public should get only part of the information which is necessary for them. And of course, we should improve the procedure of selection in the way that the civil society will have an opportunity to respond quicker. In your paragraph 8 of the motivation letter, you claim that the activity of the new HQCJ should be based on the principle of common sense. What do you mean by this principle of common sense for the HQCJ? Well, I always keep telling my students about the task set by one American professor at the exam. It was the case when two neighbors, their apples are falling on tulips and are destroying tulips on the two neighboring plots. So how do we solve the problem? Well, they applied different approaches, but everybody got a bad mark. Why? Because the tulips actually are in blossom in April or May, but apples are falling down in September. So sometimes when some people come to court and claim that there is a dispute as such, and the judge is applying different norms of the law, but in fact there is no dispute there. They have just come to get some decision what they want to probably hide away some other legal relationships. They know why they have come there. So there are some obvious things, and these things could not be ignored. Or, for example, it's about inheritance cases when somebody claims that mother had been saving money all her life long. Okay, thank you for your answers, and let me give the floor to the chairman. Thank you, Yevhen. Thank you. Please, you are welcome. Well, Maxim, of course, it's very good that you are assessing the work of our selection commission and our subjective opinion as something that is good and adequate and follows all the criteria. But you also have to realize that if you pay such compliments during the interview, it's a kind of a psychological bribe. But anyway, thank you. Please, could you answer the following question? Over the recent period of time, there has been an active discussion in the field of law, in the legal community, of the concept of development of the future composition of the Constitutional Court and establishment of the group of experts who will be making an assessment of the candidates for the Constitutional Court. And actually the criteria are going to be the same: professional competence and integrity. And the barrier here is the quantitative composition. Shall there be 3 foreign experts and 3 Ukrainian experts, or shall there be 4 foreign experts and 3 Ukrainian experts? This enabling foreign experts to have their prevailing vote in the selection. The Venice Commission and the civil society organizations actually do support the latter approach, the second one. What do you think of this? Should we still trust foreign experts more, even if this is done for one single time or for a certain period of time? Or should Ukraine still keep this balance in passing decisions like that when making selections for such important positions in so important institutions? Because you understand, a judge of the Constitutional Court is appointed for 9 years, and actually he will work over the next almost 10 years, and he will be developing the legal policy in Ukraine. What do you think of that? Well, first of all, let me tell you that it was not me who asked the questions. You just asked and I gave the answer. That's why my compliment was not a kind of a bribe. And, you know, I'm still waiting about the question about your commission, why you have 6 members. No, I'm not going to ask this question about my commission, our commission. Concerning your question about the Constitutional Court, I would voice very simple reasoning. For example, if we take the example of the joint stock company, and you have the distribution of votes 50-50. That is the worst scenario for the joint stock company. And I always tell my clients, if you can have it the other way around, that would be much better. I mean that it should not be 50-50 in terms of distribution of voting. So because of this, I think that we shouldn't have the even number of members. Concerning whether preferences should be given to foreign experts, to our experts, well, we are talking about development of trust, and we are using the buyer's model based on previous experience, and previous experience has shown that there is high likelihood and probability that national experts will still be appointed with some bias. And that's why I think that should be 4-3 in favor of foreign experts. While communicating with you, I'd like to say that you seem to be quite an honest person, so sometimes too straightforward, and you seem to be very self-critical. I don't think that self-criticism is a negative trait of character, because self-criticism is something that is necessary for a judge, in particular a judge who has been working for a period of time. Sometimes the self-criticism often disappears with them, and that is not always changing the situation for the better. You, as a person who is always responsible for yourself, you are used to passing individual decisions and developing your own schedule, your own conditions of work. Will it not be psychologically difficult for you to work in a team, because the HQCJ is a joint body, and to always take into account the opinions of other colleagues, and within the nearest 4 years, if suppose you are appointed a member of the HQCJ, so you will have to somehow not that directly and straightforwardly pass decisions. You will have to take into account the standpoints of your colleagues. Well, let me also specify that I pass a lot of decisions on my own, but actually I have a team, and we have to solve the tasks. Yes, but you have selected your team on your own, and if you become a member of the HQCJ, you will be in the team with 15 people selected by other people beyond your will, that are not your colleagues, your friends, because you selected the people for your team on your own, but these will be people you don't know with different psychological portraits. Well, that's true. I don't think that I will become less straightforward because of that. I don't like the word compromise, but if we use this word, I actually had to reach a compromise with other lawyers than with IT guys. So I'm not a person who solves everything on my own. When I work with programmers, they start working at 8 in the evening, and you can tell them 100 times that it's not convenient for you to start working in the nighttime, in the evening, but he will still work in the evening, and you have to adjust to that. Okay, you can go to the market and to look for the IT programmer who will work since morning till evening, but my programmer is better. He has proper skills, and then I adjust to his work. But it was me who selected him. But anyway, I have to adjust to him. So I think that this is the task, well, not that much only of you and the High Council of Justice, but if there is one person that does not fit this team, that will be actually partially your mistakes. That's why development of the team with all possible interaction is the issue that really you are in charge of. And you know, the selection criteria also include psychological portraits, and their compatibility is not our criteria. We have the criteria set by the law, and we don't have to deal with this compatibility, psychological compatibility issue. And also, we don't have such a wide selection of candidates to also take into account their psychological compatibility. Okay, thank you for your answering the competition. Thank you for answering my questions, Mr. Chairman. I'm done. Thank you, Yevhen. Are there any further questions? No? Maksym, our interview is about to finish. Please sum it up. Well, I will not try to give any conclusions. I would just ask the Commission. When you have a discussion on me and on me as a candidate for the final shortlist, and there is an alternative with Mr. Sabotage, whom you had yesterday, select him. Well, quite an unconventional wish expressed. And this is the end of the interview. Thank you for your participation. Stay safe and good luck. Thank you. Goodbye.